Hello and welcome once again to GN Live. My name is Gilbert Nyambavum. First of all, thank you ever so much to people who are now following the program. We see you. We are really humbled by your support and hope to continue to earn and deserve it. This week we want to focus on a major development regarding Zimbabwe here in the UK. I don't know how this story did not make the headlines, but that's why we are here. That's our job, to mainstream those issues which are important but are somehow not making the conversation. Now, Zimbabwe suffered a major setback in the UK Supreme Court in a long-running international investment dispute. It was a body blow. Harare has been trying over the past few years, going back to 2015, I think, to block enforcement of a $125 million arbitration award. But this week, on Wednesday actually, the UK's highest court unanimously dismissed Zimbabwe's appeal. This was really Zimbabwe's last throw of the dice, and it did not succeed. This decision clears the way for the award to be enforced here in Britain. And it is part of a broader legal battle that has already seen Zimbabwe being ordered to pay even more money in the United States, some 440 million US dollars, which we'll explain later on in the program. So what exactly happened? Some of you might rightly ask. How do we get to have a Zimbabwean legal dispute appearing in the UK Supreme Court? And what's supposed to happen next? I mean, what happened to those traditional defenses of sovereign immunity? The idea that UK courts cannot have jurisdiction over matters that are domestic to Zimbabwe. We're going to explain that to you after this break. Stay with us. Welcome back. My name is Gilbert Nyambavwe and this is GN Live. Like I said earlier on, this week we're focusing on a major legal development relating to Zimbabwe here in the UK. The country had an appeal before the UK Supreme Court dismissed relating to an international investment dispute. But to understand this case, I need to explain two legal frameworks which are relevant to the case, without which we may not really understand what was going on. The first one, there is a framework called the International Center for the Settlement of Investment Disputes, or ICSID, ICSID. This is a World Bank arbitration system which was designed to help resolve disputes between governments and foreign investors. Zimbabwe signed up to ICSID in 1991, and the framework came into force for Zimbabwe in 1994. The scheme globally is some 165 countries signed up, and that includes the UK and the United States. There's a reason why I'm particularly citing the US, and I'm going to explain a bit later. The second legal framework we need to keep in mind is the Bilateral Investment Treaty between Zimbabwe and Switzerland. That particular agreement was signed in 1996 and came into force in 2001. Its purpose was to protect and encourage investments between the two countries, Zimbabwe and Switzerland. More importantly, however, the treaty allowed investors to take disputes with the Zimbabwean government for arbitration under the ICSID framework. In other words, any disputes that arose between Zimbabwe and the investors could be taken to the World Bank's ICSID framework. Now, one of the investments which was covered under that bilateral investment treaty related to two Swiss incorporated companies which were operating in Zimbabwe. One was Border Timbers, the other one was Hangani Development Company. These companies held agricultural land investments in Zimbabwe, which land was later expropriated under the country's fast-track land reform program without compensation. The companies then initiated arbitration proceedings against Zimbabwe under the Bilateral Investment Treaty. Remember that the Bilateral Investment Treaty allowed any disputes to be taken to the ICSID framework, and that's exactly what the two companies did in this case. In July 2015, the ICSID Arbitration Tribunal ruled in favor of the investors, Border Timbers and Hangani, and Zimbabwe was ordered to pay $124 million in compensation for the land which was taken for resettlement, plus some $1 million in additional charges which are described as moral damages as well as legal costs. However, winning an arbitration award is only one part of the process, and perhaps the easier one. The investors still needed to enforce the award, and quite clearly, it wasn't going to be easy to get this award enforced in Zimbabwe's own courts. So what do? This is how the case comes to the UK courts. And this is where the ICSID convention gets engaged again. And the commitments we signed up to when we joined it become our problem. Under Article 54 of the convention, every member state must recognize an ICSID arbitration award as binding and enforce the financial obligations of that award as if they were a final judgment in their own courts. In practical terms, what this means is that the investors could seek enforcement of the award in any ICSID member country. So, and that's exactly what they did. In September 2021, Border Timbers applied to register the arbitration award in England. The London High Court duly registered the award in October 2021, allowing it to be enforced through the UK legal system. And that's when Zimbabwe moved to try and stop this. And the legal resort that Zimbabwe tried to use is the concept of sovereign immunity under the UK's State Immunities Act, SIA, of 1978. In simple terms, Zimbabwe claimed that foreign states should generally be immune from the jurisdiction of UK courts. In other words, UK courts have no jurisdiction over Zimbabwe. But the High Court, the UK High Court, rejected that argument. Zimbabwe appealed, and the matter went to the appeal court, which also dismissed Zimbabwe's challenge in 2024. Harare then took the matter to the UK Supreme Court in its final attempt to block enforcement. Really, Zimbabwe's last throw of the dice. And this week, the UK Supreme Court unanimously ruled against Zimbabwe. The judges said that the wording of Article 54 of the ICSID Convention is very clear. By signing up to the convention, member countries agree that arbitration awards will be recognized and enforced in other member states as if they were final domestic court judgments. The court concluded that by signing up to ICSID, as Zimbabwe did, the country had effectively accepted that sovereign immunity could not be used to block enforcement of such awards. Because the convention is very clear that awards must be recognized and enforced by all member countries. And so if you sign up to a convention which says that, you can't then claim sovereign immunity. So on those grounds, Zimbabwe's appeal was dismissed. So this development, this ruling by the UK Supreme Court, what it means is that the arbitration award, which is now worth $154 million if you add interest, never mind the legal costs for ourselves. The ruling means that arbitration award remains registered and enforceable in the United Kingdom. So what happens next? Well, Zimbabwe may still raise limited technical defenses during the enforcement process. And actually, the Court of Appeal had already send some of those issues back to the High Court for further directions. But the central legal argument, sovereign immunity, has now been definitively rejected by the Supreme Court and is no longer available to Zimbabwe. In other words, if you sign up to a convention that says its arbitration awards must be recognized and enforced by all member states, you can't then claim sovereign immunity. So that's the landmark ruling by the UK Supreme Court. And there was a parallel case. There's actually a parallel case relating to the same issues underway in the American courts. Border Timbers, Hangani Development Company, and the major investor in these two companies, the von Pezold family, had pursued enforcement proceedings to the United States in addition to the UK. Remember, they under the convention, they can pursue enforcement in any of the member states. And the US courts ruled against Zimbabwe again on the basis that sovereign immunity does not apply, where you have signed up to a convention which says, these arbitration awards must be recognized by all member states. So these cases are part of a wider web of international disputes stemming from Zimbabwe's land reform program. Many Some may remember that in 2020, the country, in a bid to try and deal with these things, came up with a proposal in an agreement with some farmers to pay $3.5 billion in compensation to the white former commercial farmers whose land was taken for resettlement. However, progress in terms of processing the payments has been slow because obviously the money is short. And some farmers, out of frustration, have now appealed to US President Donald Trump to intervene and try and put pressure on Zimbabwe to make these payments. They are inspired, of course, by comments Trump has been making in respect of white people in South Africa. But for now, Zimbabwe's immediate concern is a growing number of international awards that creditors are now trying to enforce around the world. And with the UK's Supreme Court decision on Wednesday this week, one of Zimbabwe's last legal barriers in Britain, the resort to sovereign immunity and the issue of jurisdiction, has now fallen and is no longer available to us, which means that decision is now likely to be executed and enforced in the UK. Thank you for watching.